Well, welcome everyone, and welcome to so many. It's so great to see so many familiar faces. Welcome to the newcomers. This is part of our client seminar series, which is actually a client-nominated topic. So at the end of the session, there'll be a QR code that pops up, and that's your opportunity to actually nominate on subjects. So we try and deliver what you want to hear, not what we think you want to hear about. So today we'll be exploring with you the wild, wonderful world of alleged bullying, harassment and victimisation, which is under the provisions of the New South Wales IR Act. Now, we're well aware, of course, that there's new provisions under the workers' compensation legislation as well. What we want to talk about is actual cases we've had so far in the similar jurisdiction that already exists or existed since October last year, and use it as a window of what possibly you might expect, but also from the lens of our some recent, well, actually the bulk of the cases we've had so far have been self-represented litigants using artificial intelligence. So we want to be able to share with you those experiences. Before I start, I'd just like to acknowledge the Gadigal people of the Aurora Nation, who are the traditional custodians of the land, and pay my respect to elders past, present, and those emerging with us, and welcome. Now, you may have, well, for those of you who read the Financial Review, I've got a habit of doing it, but there's been a whole series of headlines as recently as Monday this week and the weeks before about the incident or the preponderance of AI litigation, particularly in employment cases. And we have to say that's certainly been our experience. It started, it's actually not just limited to the Fair Work Commission. It's in the Federal Court, the Federal Circuit Family Court, and now also the Industrial Relations Commission. And I'm also aware too, although I don't appear in the Personal Injury Commission, there's been Personal Injury Commission examples of AI where applications have been made, including by employers, where they've been denied because they breach the practice rules. The Industrial Relations Commission has a practice note 33 on generative AI that commenced on the 19th of February last year, soon after the Supreme Court published its practice note on generative AI, which commenced on the 3rd of February last year. But there's been early publicity about AI in litigation, has largely, initially started with suburban solicitors and under-resourced barristers submitting court documents that had hallucinated cases and false references to statutes. Highly embarrassing, and the courts have issued stern warnings to practitioners of their professional obligations and consequences. I can assure you that's never happened to us, but it's embarrassing when you see it happen to your opponents and they haven't checked. Sometimes with senior counsel involved who hasn't checked either. But most recent media attention has been focused on the surge in self-represented litigants, particularly employees who are weaponising generative AI tools to barrage their employers, and I predict their insurers as well. And in fact, we've got a live case where the insurers now are brought into it, demanding, and when I say demanding, they are repeatedly demanding corrective action, settlements, all sorts of bizarre requests, and then they use AI to then generate an originating process, kick the proceedings off, and we've just we're in a case which has got closing submissions next week, where the entire case, so the entire body of evidence in all correspondence has been AI generated, the originating process are AI generated, all submissions are AI generated, and even the self-represented litigant used AI to generate cross-examination questions, which weren't good, but he did it. Last year, just to give you an insight, these headlines aren't pumped up, just in the federal court, there was a 125% surge in self-represented litigants, and so much so that that court has had to publish it was late in publishing a practice note on generative AI only in April this year. And I suspect it might have been one of the cases I'm battling with, where the self-represented litigant there, who happens to have a master's in artificial intelligence, so he knows what he's doing, has at the moment 13 active matters in that court, 3 against the registrar for refusals to accept AI-generated originating processes. And we're now waiting on a judgment because he's trying to have the judge disqualified because he's not happy with the judge. But we've also had a Federal Circuit and Family Court judge most recently in a judgment say AI came perilously close to contempt because it had hallucinated evidence and also dragged a case on for months at significant expense to the employer. And so that's the warning that, that this is the thing that we're dealing with at the moment. The Fair Work Commission has been inundated with AI claims, so much so that you might have read the federal government introduced some recent reforms to actually ease the administrative burden on the Commission and try and weed out unmeritorious claims. We're starting to see some processes adopted there for early dismissal and disposal of matters. And just to give you an idea, just in last financial year, they had a 200% increase in self-represented litigant matters, and they already had a large body already. And the president of that commission has publicly spoken about the challenges of AI that he's dealt with. This year alone, and we'll talk about some of these cases, we'll share with you our experience with AI self-represented litigants and how it distorts actually the real legal issues. So we'll also talk about the real legal issues. But we've certainly also noticed, and this is something for thought-provoking discussion later, staff members and managers of clients, so employers, who may have used AI in the generation of documents, and they might consider it to be administrative tasks, but they've generated documents that then become relied upon in a tree of decision-making in the organisation, leading up to disciplinary or dismissal processes. That is something that concerns us as well, and something that I think those in the room here should be aware of, that this is not just self-represented litigants, it's also possibly within your organisation where people are using it as a tool. But the warning there is that these practice notes on generative AI apply equally to employers as well as self-represented litigants, as well as practitioners. So hopefully what we can explore with you in the context of recent reforms is what to expect and use some of the case examples we have as a predictor of what we might be seeing in the new jurisdiction in the Industrial Relations Commission dealing with workers' compensation claims under that legislation. Uses similar language, not identical, but similar. Just in terms of, sorry, that slide there was just an observation that's been made in the Federal Family and Circuit Court, where the self-represented litigant placed blind faith in AI, thinking that he had a legal expert on board. He certainly didn't, but also the judge wasn't prepared in that instance just to throw the case out because he'd been misled by AI. But that creates costs and delay because you've now got somebody who's using it as an excuse. And we're all keeping in mind too, the Industrial Relations Commission, a bit like the other tribunals, is supposed to be quick, just and cheap. But there's a fine balancing line between that and allowing free rein to people to commence proceedings that are very difficult to manage. Just so what we plan to cover today is, we've called it the new bullying jurisdiction and the new sexual harassment jurisdiction. What we're talking about is the IR Act jurisdiction that's existed since October, because we've got live cases there. We don't have any cases under the workers' compensation similar provisions. But we're hoping that that can provide an illustration of what to expect and how the Commission's got slightly different procedural rules, but it's similar enough to get a comparison. We also want to touch on the newly sort of updated victimisation provision provisions in the IR Act, because there's some interesting crossovers. And also the first case we've had with the bullying matter has been joined with a victimisation case, so they're run in parallel. And then what we wanted to do is offer some tips to you. And I was talking to some of you this morning and over the coffee and breakfast about how to detect it, because there are telltale signs that we've learned and are becoming more apparent. Some correspondence looks very convincing, but when you scratch under the surface, you realise there's no substance to it, but it looks fantastic on the surface. Whilst as you're probably aware, since 1st of July this year, there's been new relevant conduct provisions that have commenced in the Commission. And as I've said, those processes have yet to play out in the Commission, but there is a new practice note that explains the Commission's process, Practice Note 38. It was recently updated last week. Hopefully, from the examples we'll give, it will generate some thought and prediction on what will happen under that jurisdiction. All right, well, I'll hand over now to Juliana, who will deal with the bullying aspects of the talk.
Thanks, Darren. So as Darren has already mentioned, this new bullying jurisdiction under the IR Act came into effect in October last year. It's interesting and important that the jurisdiction appears to have retrospective effect. So applicants can bring claims for alleged bullying that occurred before October last year, as long as there's a continued risk that the bullying occurred. And unlike the sexual harassment and victimisation jurisdictions under the IR Act, there's no time limit imposed on when someone can bring a claim. So theoretically, the bullying could have occurred 10 years ago, but as long as there's a continued risk that the bullying will continue, you can still bring a bullying claim under the IR Act. The IR Act largely adopts what the test is used in the Fair Work Commission. So helpfully, the Fair Work Commission decisions are very persuasive in the IRC, which is what we've seen so far. The major differences between the two jurisdictions is the Fair Work Commission cannot order any monetary damages for any bullying found, whereas the IRC under Section 144G can order damages up to $100,000, which is very enticing for some self-represented litigants for sure. Now, bullying under Section 144C of the Industrial Relations Act, like the Fair Work Act, it prescribes that a person has to be bullied at work that a person is bullied at work if they've been subject to repeated unreasonable behaviour that creates a risk to their health and safety. Section 144C1, so the definition of bullying, doesn't apply to reasonable management action carried out in a reasonable way, and we'll come to what that means in the coming slides. Now, the elements to make out a bullying claim, the applicant will need to establish that they were firstly at work when the conduct occurred, that an individual or a group has repeatedly behaved towards them and that behaviour was unreasonable. And then that behaviour creates a risk to health and safety. And also that the bullying will continue. So there have been a few decisions in the IRC on the new jurisdiction under the IR Act. There's one decision that has been published by Commissioner Muir, which is quite helpful. It's the decision of Hay and Thaler. And in that decision, Commissioner Muir grapples with what repeated unreasonable behaviour means, and he pretty much adopts what was said in the case, in the Fair Work decision of RESB, and he says that unreasonable behaviour should be considered to be behaviour that a reasonable person, having regard to the circumstances, may consider to be unreasonable. That is, the assessment of the behaviour is an objective test, having regard to the relevant circumstances applying at the time. So it requires an objective assessment of the circumstances at the time in which the conduct occurred. And as Commissioner Muir put in his even more recent decision of HET and Health Secretary in respect of health share, he said the impugned behaviour is to be assessed objectively. Further, the question is the unreasonableness of the behaviour and the risk of creating health and safety issues. Behaviour need not be perfect to elude being unreasonable. The fact that there may have been a better way will not automatically make the conduct unreasonable. The unreasonable behaviour also needs to be repeated. It needs to occur more than once, although the behaviour doesn't need to be the same. It can be different. It can be different examples of bullying, but we'll get to that at a later slide. In the Fair Work decision of Amy Mack and the Bank of Queensland, Vice President Hatcher quite helpfully listed features that one might expect to find in a course of repeated unreasonable behaviour, and that included things like intimidation, coercion, threats, humiliation, singling out, malicious pranks, belittling, conspiracy to harm, rumour mongering. There was quite a long list, but that's what he gave examples of. Now, as we touched on the definition of bullying at work under Section 144C, one of the preconditions to satisfying the definition of bullying is that the conduct occurred while the employee was at work. So whether the employee is considered at work when the repeated unreasonable conduct occurred will depend on the particular circumstances of each case. And in Hay and Thaler, going back to that decision, Commissioner Muir adopted what was said in the full bench decision in the Fair Work Commission of Bowker, which recognised that there's a sharp distinction that may be drawn in particular circumstances as to being at work and not being at work, and that the question is quite simply, you are at work or you are not at work. If you have finished work for the day and left your workplace, you are not at work. Logically, if you were on annual leave, you are not at work. If a worker is assailed by an offensive poster at their workplace, that could constitute being bullied at work. If they are assailed by the same poster at the local pub after work hours, they could not have been bullied at work by the poster. So although what appears to be a somewhat clear distinction may become murky in circumstances where, for example, an employee takes another employee's social media post to be unreasonable behaviour, and the question may arise, well, whether the employee saw the media post at work or was it outside work? And that was the facts of the case in Hay and Thaler, where Commissioner Muir actually summarily dismissed aspects of that applicant's bullying case because he considered that that applicant was not at work when the alleged bullying conduct occurred. In this case, the employee was actually certified unable to work and receiving workers' compensation payments at the time, that she said that the bullying behaviour occurred, which was that there was a social media post that upset her. And it was also found that the social media postings relevant to the conduct was neither involving the worker's employer or place of employment. So lastly, I just want to touch on that Section 144G, which gives the Commission powers to make orders, as to Section 144C, relevantly states that the bullying there needs to be a risk that the bullying will continue at work. So as we touched in one of the earlier slides, Section 144C1 does not apply to reasonable management action carried out in a reasonable way. When determining whether reasonable management action is reasonable, it's an objective assessment of the action in the context of the circumstances and knowledge of those individuals involved at the time. So there may be a consideration of the emotional state and psychological health of the worker. The test is not whether it could have been undertaken in a manner that was more reasonable or more acceptable. And so on the slide there, we have some examples of what is reasonable management action. for example, performance appraisals, counselling or disciplining a worker for misconduct, or investigating alleged misconduct. So what is not bullying? These are some examples on the slide of what the Commission has found not to be bullying. I won't go through all of them, but I think the funny one is the second dot point. That was a Victorian Supreme Court case, and basically the employee in that case alleged that some other person, I think it was a manager, was farting in an open space and in the workplace and was farting on him. And yeah, and the court basically said, well, the court found that that conduct didn't occur, but even if it did, it didn't amount to bullying. Now, the other case I also want to touch on is the case of Alison Hawking there on the screen, which is the fourth dot point. This is a case that actually Darren was the advocate in, and we got the decision about 2 weeks ago. This was an interesting case because the applicant in that case had asked her employer to have her hours reduced because she was saying that she was overworked and that she was at risk of burnout. So the employer, as a good employer who has work health safety duties, did so, and then she later claimed that that was bullying. The Commission obviously did not agree with that. Now, this is a recent case example, as Darren has been talking about the use of AI. This is a case that Darren and I have been working on and featured a lot of AI. The applicant used AI to generate his bullying application and to allege that he had been bullied by another colleague. And he said that there was a few instances of what he says was the unreasonable behaviour. Apparently his colleague said to him, "Where are you at?" in an aggressive and unwelcoming manner. He searched his Facebook page and then apparently made derogatory comments to another colleague about such posts. And then apparently he also spread a rumour about the applicant being in a romantic relationship with another employee. Under cross-examination, the applicant admitted that the only incident where he was actually at work was the first one where his colleague said to him, "Where are you at?" in an aggressive manner. And we had run this case as a summary dismissal. So we had asked the Commission to summarily dismiss the matter because we said it had no reasonable prospects of success. And Commissioner O'Sullivan agreed with us because he said that the applicant was on workers' compensation leave when the other two incidents occurred, and so he was therefore not at work. And when you look at what's left, it was only the first instance, and that can't be repeated unreasonable behaviour. So he didn't meet the definition of bullying within Section 144C. Now, another case, this is a Fair Work decision case, and the reason why I wanted to go through this is that the Commission made some helpful observations at the end of, I think, what a lot of people have probably been experiencing with employees kind of badgering them with probably the assistance of AI. So in that decision, the employee had alleged that he had been bullied on a number of grounds, one of them being that his manager had changed his position title in his contract each year, and that was humiliating to him. But of course, the Commission didn't find that to be bullying, and the Commission at the end of the judgment actually touched on a concept known as upward bullying, and he said that although the applicant reported to his manager, he refused to comply with directions, questioning every decision he made and persistently undermining his authority. He refused to comply with reasonable management directions, was obstructive, and gave evidence that he did not believe he should have to comply with the directions of his manager. He would often send multiple emails in succession challenging the manager's decision or insisting that the manager acquiesce to some of his demands. Some of this conduct, in my view, was consistent with upward bullying. the applicant was unable to identify his own shortcomings or how his behaviour contributed to the circumstances in which he finds himself in. I'm not satisfied that the applicant was bullied. Instead, the manager, as the applicant's direct manager, has had to carefully navigate the applicant's unreasonable behaviour and at times distorted perception of events. The applicant has much of a responsibility to comply with the company's policies and show respectful behaviour at work as the manager. Now, there's an upward bullying expert, Maureen Kine, hopefully I'm not butchering that, who has said that AI is actually one of the factors driving a significant increase in the targeting of senior workplace leaders. And as I said, Darren and I have seen it ourselves in some of our recent cases where you just have employees using AI to send repeated unreasonable demands to their manager and even threatening them in some circumstances. Now, probably the most interesting aspect and appealing aspect to self-represented litigants is the IRC's under Section 144G, the ability to award damages up to $100,000. The Commission has not yet published a decision awarding damages to an employee under Section 144G. In the second reading speech of the bill, the Legislative Assembly kind of explained that the power to award damages is based on the powers currently vested with NCAT under the Anti-Discrimination Act. And under that regime, it's long been held that damages for breaches must be compensatory in nature, not punitive, and should only be awarded to a party in the same to put the party in the same position they would have been had the breach not occurred. So the onus will be on applicants to prove that they have suffered some sort of compensable loss as a result of the bullying. So I'll now hand over back to Darren to talk about sexual harassment.
Thank you. Despite those jurisdictional limits, we're dealing with somebody who thinks they're entitled, 70 times more that, but and I think AI told him so. So the new sexual harassment provisions under the IR Act also came into effect October last year. It too appears to have retrospective operation, meaning claims could be made theoretically before then. However, unlike the bullying jurisdiction, there's an actual 24-month limit on making sexual harassment. So the complaint needs to be within 24 months of when they allege to have suffered sexual harassment on the last occasion. And that's similar to what exists under the Anti-Discrimination Act. But some might think, well, that's a bit harsh compared to bullying cases, because some would consider sexual harassment to be of a more significant or just as significant consequence to people. And there's also another limit, which doesn't exist under the bullying provisions too, is if there's it does, but if they've already initiated another sexual harassment or discrimination claim under anti-discrimination laws. And they also cannot receive compensation if they have already received compensation under another anti-discrimination law. So there's a layering of limitations for sexual harassment that just don't exist for the bullying jurisdiction, which is interesting. I won't labour on this because the definition is substantially the same as what it is under the Anti-Discrimination Act, Section 22, capital A. There are some differences though, and it's not as broad. And importantly, and in the cases that I'll talk about, they still need to prove the following elements: that there's unwelcome conduct of sexual nature, or it may involve unwelcome sexual favours or advances, and having regard to all the circumstances. This is the interesting part. So that the first part is subjective in that it's how the person perceives the conduct. But then there's an objective overlay test to say, well, having regard to all the circumstances, would a reasonable person have anticipated that the conduct would have offended, humiliated, or aggrieved the person? Which again is it's an objective subjective test too, because you're looking at it from a reasonable person, looking at the person who says they were sexually harassed, but taking into account their susceptibilities or predisposition to harm. It's a complicated jurisdiction, and I've got a case that will explain why it's complicated. And you think too that a lot of sexual harassment cases are really clear cut. In my experience, and I've been doing this for over 34 years, it's very rare. Well, the cases that are clear cut and obviously sexual harassment are resolved early and go away. It's the ones that go to arbitration are the ones where it's it could go either way, and it's not obvious. So often, often the cases you read about are not the best cases, but they're the ones that make the law. So there actually isn't any decided sexual harassment matters in the IRC yet, but luckily there's a Court of Appeal decision that looks at sexual harassment, which I think is even more important. These are the connection to work provisions, which is a little bit different to what the Anti-Discrimination Act defines in its provisions, which are slightly broader for workplace participants. But here it's all about whether or not there's a connection to an employee or a prospective employee and a person conducting a business or undertaking. So that's different. That's a concept that's similar to work health and safety ideas. Section 144 is interesting because it says there can be a contravention of that section by an employer agent of the person who, as well as if the act is in connection with the employment of the employer as in the duties of the agent of. So there's an agency sort of concept too, as well as the usual vicarious liability that's deemed to the employer, but also a PCBU as a broader concept. And again, it's said to be an attractive jurisdiction, even though we haven't had any live cases yet, because there's another $100,000 lure of reward there, again for compensation for loss in damages. So it's not punitive, compensatory damages only. Sorry. But you can obtain some interesting orders, such as prohibition orders to prevent repeated sexual. That's a little bit like stop bullying. And there can be civil penalties for breach of those prohibition orders. So that's different. There can also be orders which are a little bit vague about performance of reasonable actions or course of actions to be carried out to redress loss or damage. What we've seen in cases in the NCAP, for example, is that people ask for training for managers or apologies, but with an attachment that says that this is what we will be doing to prevent this from happening ever again, and so on. And there have been cases where such orders have been made in the NCAT, and I'd predict that the Commission would be open to doing something similar. And hence 5 is sort of that development of a program too. So if a company hasn't actually, well, in this sense, it will be it's hard to imagine a government employer would not have a policy or program in place, but it's possible that smaller agencies may not. But and in the new jurisdiction, which will be opened up to the private sector, there's a higher likelihood that there may not be a policy program or training on sexual harassment in the workplace. So particularly in certain industries where they seem to be resistant to these things. But the case I want to mention is Danes and IMED, because it's a Court of Appeal decision. And although it's actually a breach of contract case, it's an interesting case where there was a dismissal of a doctor, Danes, for bullying and sexual harassment. And so, and it's also illustrative, I think, of what I was saying are the finer points and nuances of sexual harassment cases, because in this case, it was about, typically Christmas party, fancy dress, and the theme was come dressed as something relating to your first initial name. I thought that was a bit tricky, but luckily Ms. Holly Turner had the brilliant idea of coming dressed with a holly leaf. And when I read that, I thought, gee, that's not very large. But she manufactured a large foam holly leaf and covered herself in it. And so, which would be very uncomfortable in summer in Australia, but hence why the case starts with an alleged conversation that she looked hot in the costume. And again, I thought, gee, that's a bit of a double entendre, but apparently that wasn't the allegation of sexual harassment. She actually admitted in cross that she actually was hot and sweating like a pig underneath it. The interesting incident of sexual harassment is what she described as a pelvic thrust movement by Dr. Daines after that conversation about being hot occurred. And what's strange about this case is Dr. Daines didn't deny that there was such a movement, but he described it in more culturally appropriate terms as doing a haka, which to me it seems like a very creative defence. But lo and behold, the trial judge at first instance, having the benefit of listening to Ms. Holly Turner and what she described, they had to physically do the move, which I won't try and do. I don't want it to be misinterpreted. The trial judge sort of had to engage his mind as to whether or not Dr. Daines's defence was something that engaged in conduct, well, something that in the trial judge's view was something that usually a pelvic thrust movement could be intimated as sexual in nature. But in the end, when the Court of Appeal looked at it, the Court of Appeal said, well, look, that's probably not the way to look at it. You need to look at whether or not he's engaged in conduct of a sexual nature, which is the test of sexual harassment, and not that he made a physical gesture that was capable of description as a pelvic thrust movement. So these are the finer nuances, because what you typically get in bullying, sexual harassment cases are people's descriptions of things with their own label. And it's actually not a detailed description, think physically or functionally of what happened. It's how they interpret it. And so she interpreted it as a pelvic thrust movement, which connotes something sexual to her, whereas to Dr. Daines, he said, well, obviously he was a Kiwi or something. He just said, I was just doing a haka move. And interestingly, and as the Court of Appeal said, while this may have been Ms. Bailey's perception of what she saw, and as it was reflected in her evidence at trial, the two movements were, on Mr. Daines's evidence, quite distinct, and he was adamant it was not a pelvic thrust, and still less that of being conduct of a sexual nature. So the trial judge actually preferred Dr. Daines's evidence, which it was he was in, the Court of Appeal said he was in a superior position, having the benefit of assessing the witnesses and their testimony as to which would be preferred. But it's actually a good example of how most of these cases play out, because you get people who describe things, particularly in their initial complaint, as a label, as some sort of generalized conduct to fit the sexual nature. And this is how the danger of AI, because it helps summarize and condense text into something that it perhaps physically wasn't, or it's a mislabeling of something. And that's what we find is often the problem with AI, is that it's very good at summarizing things, but also very good at mischaracterizing something in human nature that may have a different sexual or cultural meaning than what even AI would understand it to be. So I just want to touch on the new victimisation provisions too. And I won't go into detail on this because we had a presentation on this before, but I want to mention that there's new grounds that have been added to victimisation under Section 210 of the Industrial Relations Act. And interestingly, one of them is a copy of what's in the federal system. So having being victimised, and keeping in mind victimised is not defined in the Act. You have to rely on decided cases to know what that means. By making a complaint or inquiry to a public authority about their employer. And there's lots of, yes. Under the the case that we mentioned of Heslop, which I find funny because it's he slop versus AI slop. It's the very first case. The case that we had dismissed, I only established in cross-examination of him that he was not at work, and he couldn't have been at work to have become aware of the viewing of that social media post. It would be different though if the viewing of it occurred at work. And I should point out now that under the workers' compensation definition of bullying, it doesn't use at work, and it doesn't require you to prove a connection to health and safety, although it's implicit. So keep in mind there's some differences in the definitions under the workers' compensation legislation that are slightly different. But yes, there are, and there's lots of other cases where the viewing of and then discussing of social media posts at work or in connection with work. So, for example, at a retreat, where the only reason you're there is because of employment, has been enough to bring that connection in to either make it a bullying capable matter or a sexual harassment capable matter. Hopefully that clears it up.
Can you repeat the question?
So the previous.
Oh, so, yes, sorry. I don't want to miss. Are you able to remind me of the question again?
Oh, sorry. Actually, the second question. Oh, the first one?
So the people at home can hear it.
Oh, if it was repeatedly conducted, say on social media, but outside of work.
Yeah. No, sorry. So no. The answer is no, because it needs to be in the court. Well, at work, and needs to be repeated at work.
Okay.
So the answer I gave is still correct, because you would need to be either receiving the messaging at work as something that's sexual in nature and you're offended or humiliated, or it's repeated to you at work where you feel unsafe, or there's a risk to health and safety. But it's heavily fact dependent, because, and we were just fortunate that we ran the Heslop case as a summary dismissal, and I was confident enough in cross-examination to have him, well, I knew I'd have to get him to admit that there was only one incident that ever occurred at work, and that was enough to have the matter dismissed. And it's noted it's very rare in judgments to have it noted that cross-examination succeeded in proving something. I mean, despite what you see on TV, but it was one of those rare cases where it happened. So the other thing in victimisation is you can also allege that you've been victimised because you've claimed a benefit under workers' compensation legislation. That's a big sleeper because it's new. And the reason I say that is a lot of the, we've come across many, many cases of threatened dismissal and now bullying where victimisation has been added as a separate cause of action, and the cases run together as both bullying and victimisation together. And so you've got two cases in one, which is exactly what we've had in the Heslop case, where he actually had three matters at once, two separate bullying matters against two different co-workers, and victimisation for having made a complaint about it, and then saying that he was subjected to a detriment. And there's also a protection for having a characteristic protected by the Anti-Discrimination Act. That's very clumsy wording, and it's been picked up in a couple of New South Wales Commission cases already, because for example, how is sexual harassment a characteristic protected by? I mean, it's just bad drafting, and it may be that it needs to be corrected, but whilst it might be a characteristic to be pregnant or of a particular racial or ethnic background, it's not like harassment on the grounds of disability is not a characteristic, but for perhaps being someone who has a disability. But you can also bring claims as a person associated with a person who has a protection. So that's even more. We've had a couple of those too, where a carer or a parent has said they've been discriminated against at work, not because they have the characteristic, but they are the associate or carer of the person with the characteristic. So beware of that. That's a sleeper too. So yeah, I don't want to harp on this other than the common issues we've come across already, and we're running a matter next week in the State Commission on this point, is that a victimisation application has to be made within 21 days of the alleged contravention. It's often overlooked, though, and often because people lie on the application form or don't mention dates when things are alleged to have happened. But it's actually, and they have to prove that there's sufficient reason for their delay, and if they cannot, the matter can be struck out summarily. And there's actually been a number of cases already where that has been the result. I thought I'd just mention Sarsen, which is a very recent case in the last few couple of months, where, although it was interesting, it was about a 21-day time limit, but where the applicant was adding to their alleged acts of victimisation, including after making the application, but going back in time. So everything they added was making it even more out of time. And so they still had to seek leave. Of course, they didn't even bother, but it was brought up by the employer. And there it was made clear that the Commission will still need to look at everything as whether it's out of time or not. There is a possibility you could have some matters of alleged victimisation allowed in time and others that are cut off. But then you get arguments about whether they are all a chain of events that you can't sever, which has happened in discrimination cases in NCAP. But notably, Dr. Sarsen in that case was a self-represented litigant who chose AI as his advisor. Oh, yes.
Sorry, what are some of the characteristics and key allegations that occur that you see where someone has alleged that victimisation has happened?
Usually it's because, yes. So the question is, what are the usual characteristics of a complaint of victimisation? Usually it's people who say, I've made a complaint about bullying, harassment, you've done nothing about it, or what you did do about it was a detriment to me, not the person who's the bully. And the case we're dealing with at the moment, he's claiming that the detriment was moving him from one location to another to separate the two warring parties. You also get, and this happens a lot in the Fair Work Commission, where they've made complaints everywhere and they've told through their employer through AI, I've complained about you to the Ombudsman, the Privacy Commissioner. In that case we're dealing with, he's complained to the Prime Minister, the Premier, their local member, ICAC, 13 different bodies. And he said, because I did that, you've victimised me. So, yeah, people are using it. They're weaponising these provisions to attack their employer and managers and to make life difficult. That's the experience. And certainly in Sarsen, it was observed by Commissioner McDonald that, first of all, you can't use the fact that you're self-represented as some shield for bad behaviour. And it was noted that whether you're represented by a lawyer or not, all parties have a duty not to mislead the court and to follow the rules. And the Commissioner noted that I do not know whether generative artificial intelligence was used by Dr. Sarsen when he prepared his application for leave to amend, which suggests he probably did. But in any event, the Commission's Practice Note 33, use of generative artificial intelligence, the author of writ submissions and summaries of argument must verify that all citations of legal authorities, case law and legislative references actually exist, are accurate and are relevant to the proceedings. It appears that this was not done in this case. So that's an example where even on a 21-day argument, you've got fabricated cases. And in the case that Juliana and I are dealing with, we've got everything has been generated by AI, every piece of correspondence. So every witness statement, which is contrary to the practice note, but they've just gone ahead and done it. And it's being debated about whether it should be allowed. I just want to quickly note that the main distinction that's changed in victimisation is moving from a subjective test to an objective test. What does that mean? Without having to read this entire slide, New South Wales Parliament has decided in its wisdom that it didn't like what the High Court said in a particular case that related to a similar federal, the Fair Work jurisdiction, which is called general protections, adverse action, being the standard. That is, you could often overcome the reverse presumption that you've victimised somebody until you prove that you actually haven't done it for that reason. You could do it based on the subjective evidence of a manager you could put them in the witness box and say, no, in my decision making, it was totally irrelevant that the person had made 13 complaints to different regulatory bodies. I only did it for work health safety reasons, and the High Court had said in the Bendigo and Barclay case, that's enough. If you've got a manager who can say that and it's evidence that's persuasive and convincing on the balance of probabilities, that's enough. The new provisions have been changed to actually overrule the High Court's finding there, and to say you need to go back to what the court below the High Court found in Barclay and use. It's not going to be that easy anymore. You have to look at all the circumstances and not just the subjective decision makers' mind on how they thought things. And the search is what actuated the conduct, not what the person thinks he or she was actuated by, was the finding in the federal court decision. It's a big shift. And what it does is it creates a massive burden of proof problem for employers. All sorts of, in the federal court, again, I won't go through this in detail, but there are all sorts of extra complications about trying to prove things objectively outside the mind of a decision maker. And the words that are now used in the Industrial Relations Act includes conscious and unconscious thoughts. That opens up a whole world of possibilities. So much so that in one case that's been argued, which is right, and I won't go through this, it's been put that it's almost impossible for an employer to disprove the bias. Luckily, in this case of Gospinath, which interesting is another decision of Commissioner Muir, he's preferred a less extreme reading of the provisions and basically said that within the majority of cases, it shouldn't be, whilst it might be a difficult task, it's not impossible for a respondent to prove objectively that their thought and decision-making process were not infected by the alleged conduct. However, what is unconscious in the decision maker's mind is very complicated because they still need to be factored in. And it was actually the mischief that the High Court was trying to remove from the decisions because it raised the bar so significantly, and it raised all questions about, well, how on earth can you disprove that you don't have a mind infected by unconscious bias, when in fact we've been told for the last decade we all have unconscious bias. So you can imagine how easy it is in cross-examination to put to a witness, well, of course you acknowledge that you've got unconscious biases, yes, you've been on training about it, yes, you know it exists, yes, so therefore you must have it. So yeah, it's very, very difficult, and it's but as been said in Gospinath, the Commission will promise to do its best to determine, based on objective evidence before it, whether such factors outside the decision maker's mind influence their thinking. It's not very reassuring, but that's what we have. But what I wanted to raise in this context is how this affects evidence when you've got AI decision-making processes involved. And you might think, how is that possible? Well, we've already had cases across our desk in the last few months where, and it's actually been for very good reasons why clients have used AI as part of their process internally. Either it's been time cost saving to do it. They've been, or they might be people who where English is not their first language, and so they've used it for business purposes to improve the look and feel of their correspondence. In one recent case we've had, it was very helpful because they'd used AI extensively to do data analysis to prove misconduct using data sets that they had, which were very large. So, for example, it involved a person who had a GPS tracking system on their car. They had a policy to say, we will be using this data to analyse your movements. They had, it was hundreds of pages of numbers, but using AI, we were able to get a very clear map of exactly where they were driving each day. And it wasn't to the clients that they were supposed to be at. And often it involved the golf club and other things. But it was also triangulated with mobile phone data, expense claims, and toll data, which in the old days, I used to have to do that using the human brain, and it would take forever and it's very expensive. But with AI, you can do it very, very quickly, and you get a nice end product that wraps it all up. The problem is that you can also go too far and then use it to then generate correspondence from it, which is what we saw, and then decisions that were made based on that analysis. And so the danger there is, well, what if the English language model system you're using, which you might be using because you don't have English as a first language to improve your English, is making culturally biased or gender biased assumptions about behaviours simply because the preponderance of information online is generated by certain people who tend to promote a certain way of life, which may not reflect what the silent majority actually do. But online, it's this strange world of looks maxes and right-wing extremists and other sort of extreme views of the world that don't accord with what we really live in. And so we actually are seeing, and the danger is that before we were instructed, in one matter, the client actually had prepared their formal employer response using AI as well. And so based on everything that they generated in their decision-making process, which looked fine on the surface, but when we dug underneath it, there was some problems. The main problem, though, is, as I mentioned at the beginning, the practice note requires you to declare the use of AI and also to declare that you haven't used it to generate evidence. And if you have, you need to get, there has to be special circumstances established as to why you should be permitted to rely on it. So that can be a fatal move if you haven't disclosed it up front. So it's not just for self-represented litigants, but we're finding that the bulk of particularly bullying matters at the moment are self-represented litigants who are weaponising AI and using it in a way that one judge has described as relying on a sycophantic advisor who has they have no practicing certificate for law. They are not admitted into any jurisdiction in Australia as a lawyer. The AI owes no moral or ethical duties to the court, and yet it just feeds you what you want to hear, not what the objective truth is. That's the danger with it. And then we've also noticed that there's an escalation of AI-fueled anger and hate that ends up in conflict, and often it makes it very difficult to conciliate matters after that level of hatred has been exchanged. So at this point, I just thought we'd look at, in closing and open to questions as well, how do you know whether you're dealing with AI slop or AI generated material? Certainly we've picked up in the cases we've been dealing with some certain telltale signs. One of the obvious ones is not the usual having to dig around to find whether or not cases or statutory references are actually exist, which is one telltale, but that's a lot of work. But often it's just in the appearance of the text. So a common example is you'll get a submission that or an application that has a number brackets and a summary of I don't know anyone who does headings like that, but AI does it. Or AI often uses what's called an M dash, which is an elongated. And again, I don't know who uses it and how, but AI uses it all the time. It's this M dash, an elongated sort of dash symbol, and strange spacing, formatting, like with blue headings.
Blue writing, yeah.
Yeah. We've also noticed, and again, it might be that the text appears to be quite good, but when you read the tone of it, it's often filtered. It's filtered summaries of things where there's overgeneralizations. There's no particular. So in the federal court matter, the pleadings that were generated look fine on the surface, but then there's usually no particulars of facts, or the references to statute is just a repeat of what the statute says. It's not. There's no attempt at all to put facts within the meaning of the statute. It's also, it can be overly aggressive language. So I think AI tends to be, because it's dehumanized, and I was commenting on this with some of you this morning, it misses the mark in terms of the tone of language used. So it's often overly dramatic or aggressive. And the case we're dealing with, he saw no problem alleging that his managers had committed the crime of perverting the course of justice, or defaming him and sending defamation notices, or financial crimes because he hadn't been paid properly. It's just extreme language that's used, but they just accept that, oh, okay, well, the AI's told me that, so therefore it's true, and there's nothing wrong in asserting my legal rights. Any other things you can think of? But
I think let's move on to the tips.
Yeah,
and how to do it.
I'll let you.
So one tip that we have is don't be afraid to move the commission nice and early in a matter to have it summarily dismissed if there's no reasonable prospects. You can save yourself a lot of time and money and effort of having to have all your witnesses take time out of their very busy schedules to give evidence. If you have the matter summarily dismissed, you may not need to go through all of that. Become familiar with practice note 33, which is the IR, as Darren has said, the IRC practice note. Become familiar with it, raise it in the commission. You know, the applicant has used it. He hasn't sought leave to use it. Bring that to the commission's attention. I know you wanted to talk about using about metadata in documents.
Oh, yeah. There's a danger in producing documents too as part of a summons or compulsory document process. And I actually assume people are aware of this, but if, for example, you need to redact information from documents using, say, Adobe Reader or something to black it out, which there's a lot of digital redaction that goes on. The problem with using that without removing metadata is AI can easily read below it and pick up from the metadata what is below the redaction. And so there are tools, you need to be aware of it, because we've had some matters where it's actually in the interest of the safety of people to have redactions, like their physical safety. And we made sure that there's an option in Reader and there might be other PDF software to make sure you remove the metadata, because AI can easily read behind the black marks. Same with spreadsheets. Be very, very careful about producing spreadsheets. Even if you lock them off from human viewing, AI can easily read the other cells that are hidden. And in fact, query whether or not you should be producing spreadsheets or data sets at all, because are they the original documents, or are they simply a management summary of original documents? So it's particularly important. And there's all sorts of notes that are left in enormous spreadsheets that people, only the author normally knows about, but they can be devastating if picked up in AI. So there's enormous power with AI to look at things that you and I may not ordinarily think about. But yeah, particularly metadata we've found is now easily read and also easily interpreted by AI to explain what has happened to a document. So it can actually forensically trace editing, where there's been copying, where there's been deletion. It can even predict what the text that had been removed was, because it's an expert in text prediction, like it knows. So that word that you thought, oh, we shouldn't use that, it could probably accurately predict what it was.
Another tip is if you can avoid giving readable documents to a self-represented litigant, because that, if it's not readable, it might be a bit harder for them to feed it through AI and generate some submission or affidavit in reply.
Yeah, and it's not to be obstructive. It's more the practice note is about ensuring the public interest, and so and there needs to be leave. The reason you need to give leave for using AI is to overcome the possibility that you've got a large language model that doesn't have privacy settings on it, and you're then feeding potentially confidential personal information into a public platform which is accessible to the entire world. And that's a real danger. And so in our particular matter, we actually had hard copy documents produced to the Commission with orders restricting access to visual inspection only under supervision, so that he wouldn't even photograph the documents and then feed it through a text image reader in AI. Yes?
My question is, with redacted documents, if you were to do that on Adobe and then print to PDF, would that remove the metadata issue?
Maybe not, because it might. So the question was, if you use Adobe Reader to redact and then print a new copy, whether or not that would remove the metadata. It's possible that you've just created another layer of metadata that says you sent it to print, and the other, I'm not sure, but there's a risk there that you've actually created just more metadata to explain that it was reprinted to PDF, because it's still a digital copy. So there's a big difference between producing digital documents and what we've found is if you use an old-fashioned scanner, first of all, there's no metadata, and secondly, you're still producing the document, but AI has a difficulty reading scanned documents. I don't know why, but it's because it's being just scanned as an image, not a text. So PDF is still text, it's just in another language. And AI is an expert at reading any computer language and any code. So that's why we're mentioning these things, because it can be a big difference. And in another matter we had, which was a payroll matter, our client actually didn't have digital it actually only had hard copy documents in archives. And so, but they also they created for us a spreadsheet, but that wasn't the original document. It was just for us. So the mistake that could have been made there is to hand over to a regulator a secondary document, which was their extra work to sort of feed in paper documents. So what we did there to ensure proper compliance was just deliver the paper documents to the office of the solicitors who are acting for them. Otherwise, we're just giving them an extra tool to read through and analyse. It may not be right either. The secondary document is our client's interpretation of things. It possibly right, but it may not be. Plus, it might have the metadata in it that is not helpful, including we've found secret spreadsheets hidden in large spreadsheets, which are like dummy sort of calculations to check on things which haven't been removed. So there's all sorts of risks handing up digital documents, but particularly in the era of AI. And the only other one, and this is the bane of our lives at the moment, but it's actually checking carefully for hallucinations in documents. They are there, I can assure you. The case that we've got for closing submissions next week, we detected that of all, I think there's like 48 references to different policies of the client. 46 of them are hallucinations. There's only one that's right. And the one that's right is not relevant to the case, but actually going through each of the policies, checking. And sometimes the number was correct, but the heading was wrong. But the telltale was the heading in brackets with the number at front, which is not how they're formatted. And also references to legislation that actually have no application at all. So, you know, referring to Commonwealth legislation in the New South Wales jurisdiction. And And often they don't put in even the brackets New South Wales or brackets Commonwealth. It's just the name of the act. Or as Ross was telling me earlier, just completely fictitious legislation and cases that you have to still search for to think, well, actually, is that a case that was decided recently? 9 times out of 10, it's never been decided. It's just been hallucinated entirely. But there's extra work involved because you also run the risk too that they actually have picked up a good case, and if you don't check it, you're stuffed. But that hasn't happened yet. Yes. Any other questions? I mean, we've probably met time, but anything else that anyone would like to ask, either online or in person? I don't want AI generated online. There's a lot to go through there, but hopefully that will give you an insight too into what's, from what we've heard, it's from our experience with bullying matters in particular, the age of self-represented AI litigants is on us, and also in the New South Wales Commission, the $100,000 reward at the end of the rainbow is enough to get people motivated to complain about all sorts of things as bullying or harassment. It's a nightmare. Yes.
Have you ever been able to subpoena their Google search history or their AI search history?
Only once, but yes, it is possible. Very difficult because you either, that once I was able to do it was because my client had a server that kept data logs of everything, and luckily that server had been removed from their system and preserved it all. And it was very complicated, and we needed to get an IT forensic expert. But it was crucial because that data log, they'd created a different data log because they were an IT expert themselves, but didn't realize they were going through a different server. And so we were able to match what they were saying they were doing, which was artificial, with what they actually did. And their whole defense was, it wasn't me looking at this inappropriate material at work. 86% of their working hours, it was a Romanian hacker. That was their defense. So how do you defend that? Luckily, I had on our side a junior person who had been bullied by this person, who was extremely motivated to prove that their boss was a serial. He had a serial interest in 1950s pornographic stuff. It was weird. It was weird. And also, to make things worse, he didn't just blame when we found out that we also found it on his laptop, he then blamed his teenage son, which I thought was the worst. I thought that was the worst. But anyway, it's difficult. It's possible. It's difficult. Trying to get Google or the actual companies to serve up material, very, very difficult. But it is possible if it's serious enough. I mean, if you're dealing with something that's national security or terrorism or anti-money laundering issues, it's possible, but not if it's a bullying case. Yeah.
Thank you.
Anything else? Well, look, we hope what we can do is, once we start having some real life cases in the new workers' comp contested area of relevant conduct, which is the bullying, sexual harassment, excessive work demands issues, we can, particularly if it's voted for, with the QR code, we can then plan to sort of do a survey of those cases, and it'll be interesting to see whether there's some similar patterns or different approaches that the Commission takes, particularly with bullying. Sexual harassment should be similar. Bullying is slightly different. It'll be interesting just to see if there's any different approaches in how it deals with those matters using a slightly different practice procedure. But I would suspect it will be similar. And there are opportunities already from the cases we've talked about, including the Heslop case, to be able to knock out things early if it's apparent on the face that you do not have repeated or unreasonable conduct, or you've got reasonable management action carried out in a reasonable way. Thank you very much. I think there might even still be drinks and food to grab on the way out. So welcome to stay and chat if you want to, or enjoy the rest of the day.